Hi, my name is Sarah Madden. I am legal counsel and privacy officer for the Missouri Department of Elementary and Secondary Education. I'd like to welcome you to this training. It's titled Sunshine Law Guidance, How to Navigate the Sunshine Law. And let's talk for a minute about the whys before we get started. The why for this training is first, transparency. The reason that we need to talk about transparency is, first of all, an ethical obligation to be transparent in our work. The other reason is a legal obligation. Missouri, like many other states, has a series of laws that relate to transparency. Those laws are what we're going to talk about here today. And the reason for those laws, we might be able to guess, but they have to do with the fact that we are funded by taxpayer dollars. Because of that, we're obligated to act and perform in a transparent manner. We have to basically show our work. That means that our work, our emails, our records, all need to be made available upon request with some limitations. That means that we can't do our work in secret. That means that the taxpayers have the ability to see what we're doing. And that makes sense, right? We can't be doing the work of the taxpayers in secret. And again, as I said, there's also an ethical obligation to be transparent in what we're doing. Now, we need to balance this obligation to be transparent with another obligation, and that is to protect some of the information that we handle on a daily basis. So there's, along with this transparency obligation, a confidential obligation, an obligation to confidentiality. Why is this? Well, as we all know, on a daily basis, we deal with highly sensitive records. Records that, if they were improperly disclosed, could be ruinous, could be very, very problematic for families and students and the clients that we work with. That is a heavy burden to carry. And it takes a lot of forethought and work to make sure that we balance carefully and appropriately this confidentiality and this transparency obligation appropriately. So this training is one piece of that puzzle. And I hope that you take full advantage of the FERPA training that is also going to be offered on LinkedIn. That will be a second piece of the puzzle. So with all of that said, let's go ahead and get started. The first question is, what is the Sunshine Law? What are we even talking about when we say the Sunshine Law? The very brief answer is, it's a way for the public, the media, and other governmental entities to request and access our records. So high-level takeaways for this training. The Sunshine Law has specific timeframes for responding to requests that have to be followed to avoid legal penalties. When in doubt as to whether or not something's a Sunshine Law request, we always treat it as a Sunshine Law request for the reasons that we just talked about. We want to avoid legal penalty. If we have any questions about that, we're always going to ask our legal counsel. And finally, there are minimal steps that we can all take to ensure that we're complying with the Sunshine Law. Okay, so we already talked sort of in very broad terms about what the Sunshine Law is. Let's talk more specifically. And please, as we're going through this slide, and I'm going to read it to you, which I know is not the best way to look at a slide in a PowerPoint, please keep these concepts in mind, because we're going to come back to them again and again. So sort of hold them in your mind. So Missouri's Open Meetings and Records Law, and that's just another way of referring to Missouri's Sunshine Law or Missouri's Transparency Law, or it's also known as Chapter 610 because that's where it can be found in state statute. It makes public meetings, public records, and that's what we're going to focus on here, and public votes of a public governmental body available upon request unless there is another state or federal provision of law that makes them closed. Okay, so just to recap, Sunshine Law makes public records of a public governmental body available upon request unless there's a state or federal provision that makes them closed. Okay, so all of that seems straightforward, but we need to dig into it a little bit more. That, again, is the point of this presentation. Let's go back to the beginning. If the Sunshine Law makes records of a public governmental body available upon request, what is a public governmental body? Is DESE a public governmental body? Well, that's probably the easiest thing that we'll cover in this presentation. DESE is a public governmental body. And we know that because it is a department or a division of the state. It says so in state statute. Now, when is that question a little bit harder to determine? Well, let's say we have a pre-K program that receives state or federal funding. Is that pre-K program, and we'll call it Tiny Tots, is Tiny Tots a public governmental body? Well, the answer here is sort of. It's not a public governmental body because it's not designated in statute. You're not going to look in statute and find Tiny Tots, but it's also not nothing. It's receiving state or federal funding. So what the drafters of the Sunshine Law said is, we're going to call those types of organizations quasi-public governmental bodies because by virtue of receiving that state or federal funding, they do have to comply with the Sunshine Law to a certain extent. So to the extent that they are receiving state or federal funds, those types of organizations are subject to the Sunshine Law. So our Tiny Tots example, to the extent that it receives federal or state funds, the votes, the public meetings, or the records would have to comply with the Sunshine Law. Now, why does this matter for you? It's not going to be a matter of Tiny Tots calling you and asking, am I subject to the Sunshine Law? And if you were to receive that call, I would strongly encourage you to have the vendor or our partner, our subrecipient, contact their own legal counsel. However, it's important to know this because it's really just an awareness of how it works and what is the natural effect of how our funds could cause another recipient to then be subject to the Sunshine Law. Okay, so we've already said that a public governmental body's records, upon request, become available unless there's something that makes them closed. So what does that request look like? Well, there are no magic words, and it would sure make it easier if there were. And anyone who is participating in this training who's already worked on Sunshine Law requests can tell you that there's no form. A request can come in such a variety of formats. The only thing that a request needs to do are two things. A request needs to ask for records that are maintained by the public governmental body and be in existence at the time of the request. Now, these are two concepts that are similar but different. They're related, but they are distinct. So let's talk about two hypotheticals that sort of illustrate what we're talking about here. So when we're talking about records that are maintained by the governmental body, the hypothetical here, and I'll warn you before we get started, all of my hypotheticals wouldn't exist in the real world. They truly are hypotheticals. Let's say the U.S. Department of Education contacts us and says, DESE, we're going to send you some guidance soon, but we don't have it for you yet. And then that day or the next day, we get a call from a reporter saying, we understand that you're going to be getting some guidance from the U.S. Department of Education. Can you send it to us? So what is our response to that request? Well, our response is we don't have that guidance, because if we think about what a request has to have, it has to be maintained by the public governmental body and in existence at the time of the request. do we have that record? Is it maintained by the public governmental body? Do we have that guidance? The answer is no, we don't. So think about Sunshine Law requests as binary. We either have the request, we either have the document at the time of the request, or we don't. It's either a yes or no answer. And in this case, we don't have that guidance. We've just been told we might get it. Now, in this case, do we need to call U.S. Department of Education and ask, will you send it to us because we've gotten a request? The answer is no. We never have to go outside the department to obtain records to respond to a request. Now, a follow-up here. Could we tell the reporter that we're going to be getting the guidance soon and give the reporter a time frame by which they might want to contact us? Maybe in 2 weeks, we think we're going to be getting this guidance. Sure, we could absolutely do that. That might be really helpful. Second follow-up, do we need to keep the request open because we might be getting the guidance in 2 weeks, and then send it to the reporter as soon as we get the guidance? No, we never keep a request open because, again, we go back to the idea that we either have the document at the time of the request or we don't. In this case, we don't have the document. So the request is closed when we say we don't have it at the time of the request. It's not maintained by the public governmental body. Okay, so let's go to part 2. Records in existence at the time of the request. So let's say, again, bad hypothetical, that DESE has 2 lists of school districts. We could have just one, but we keep our district list in 2. The districts are A through M and L through Z. Why we don't combine the lists, I don't know, but that's not important for this hypothetical. So let's say we get a call from a reporter asking for one district list, a list of district names, but this just one list. Do we have a responsive record that is maintained by the public governmental body and in existence at the time of the request? The answer is no, we don't. We have 2 lists. So follow up here. Should we create a new list? The answer is no, we are not required to create a new list. That's different, I suppose, than the question that I asked, should we? We'll get to that question later. So are we required to create a new list? No. Again, binary question here. Do we have the record at the time of the request? The answer is no. Follow up to that. Do we tell the reporter, well, we have 2 lists that might meet the terms of your request? Absolutely. This is a really easy hypothetical, again, where we have something that is almost identical to what's being asked for, but not quite. So we would certainly tell the reporter, we have something that's pretty close to what you're asking for. It's just not the record that you've asked for. Okay, so just to recap all of this, we never create a new document to respond to a request. We never look outside the department to respond to a Sunshine Law request. We are never obligated to do those things. If we choose to, that takes us down a different path, and we'll talk about that path later. Okay, so just sort of wrapping all of this up about what a Sunshine Law request is and isn't. A Sunshine Law request doesn't have to be in writing. It doesn't have to say that it's a Sunshine Law request, or it's a request for records, or it's being made under Chapter 610. It doesn't have to be from a Missourian, and it doesn't have to tell us why they're asking for the information. All of these things can sometimes make a request hard to discern. Sometimes we don't even know it's a request. Sometimes it's a letter to DESE telling us that they're concerned about some things. Sometimes it's a phone call chatting with us about a variety of things, but somewhere in there is also a request for records. We have to be aware. We have to be on guard. We have to be thinking all the time, wait, did somebody just also ask for a record? Because again, we go back to what we talked about very early on in the presentation. Failing to recognize when we've received a request for records could lead to penalties. Now, What do we do if we don't have a request in writing, if it's a verbal request? We can always ask the requester to put the request in writing. And we do this by saying, could you please put your request in writing? It would make it easier for us to track your request. Could you please put your request in writing? It would make it easier for us to know what you're asking for. And as to not being able to ask why they're requesting the information, we can also ask probing questions there too. When we get one of these requests that's a long, sort of half complaint, half request for records, half request for information, we can certainly ask clarifying questions and sum it up by saying, this is what we believe you've requested. Can you please confirm it for us before we go forward? All of those are appropriate and probably, things that we should be doing because, the back and forth correspondence that we do with a requester can become very important if there's a dispute and could become part of a court record if there's litigation. Okay, so we've said that the Sunshine Law makes public records of a public governmental body open unless there's something that makes them closed. So what do we mean by that? Well, we're already saying that there's a presumption of openness, right? Because, unless something makes those records closed, we're going to provide the records. That also means that if there's a dispute as to how to read the law, we're going to read the law in favor of openness. That also means that if there's something in the record that's closed, we're typically going to provide the records, but they're going to be redacted. What do we mean by that? We mean that if there is, let's say, a Social Security number or a Missouri Student Information Number, or a MOSIS ID in the records, we're not going to say, I'm sorry, we can't provide these records because they're closed, because they have confidential information. We're going to redact or black out the confidential information and provide them. It's very, very rare that we would say an entire record has so much confidential information in it that we simply can't provide it. And that all ties into this presumption of openness. Now, there are other provisions of law we need to just be aware of that also provide transparency. So we're going to divert our attention to those for a second. And I've shown them on the slide here. This slide is probably more significant, and we're going to take a little bit of time to talk about it. Section 37.070 is a transparency provision. Now, this provision says, essentially, information, data, and reports need to be made accessible to the public, and failing to provide information can be a violation of law or policy, and it always constitutes a breach of the public's trust. So let's back up for a second and take a 30,000-foot view of what we've talked about. We've got the Sunshine Law, which we've already been talking about, and even though we haven't fully talked about all these points, the Sunshine Law, we know, is pretty prescribed. It has penalty provisions, it has timing provisions, and it says you have to provide records upon request unless there's something that makes them closed. Okay, so that's the Sunshine Law, and we'll put that in the Sunshine Law bucket. So then there's this other bucket, and we can call this the transparency or information bucket. And this bucket is wholly separate and distinct from the Sunshine Law bucket. The information bucket talks about providing information and data, and if you fail to do so, it's a breach of trust. And it doesn't really have any other requirements other than what you're seeing on the screen here. Now, does that mean we don't have to comply with it in the same way we have to comply with the Sunshine Law? No, absolutely not. Both are laws that we have to comply with and we comply with every day. However, the information or transparency bucket and requirements are, I would say, a little bit more flexible as to how we respond to them. Again, the Sunshine Law requirements are rigid and no flexibility. The transparency requirements are much more flexible, and let's talk about what that means a little bit. Let's first do an example of what we're talking about here between the two different buckets. Let's say we get a request saying, I would like all of the budget books for the last 5 years for DESE. And the budget books, for those of you who don't know, are our budget submissions to the legislature that outline all of our spending for the fiscal year. So, is that a Sunshine Law request? Yes, absolutely. They're asking for a document here. Okay, compare that to, I would like how much DESE spent on transportation for vocational rehab and disability determinations for the last 5 years. Is that a Sunshine Law request? No, it's not, because they're asking for information. They're not asking for an actual record. They're not asking for a document. So here, we're not in the Sunshine Law bucket anymore. We're now in this transparency bucket, the slide that we're talking about. Do we have to respond within a certain amount of time? Do we have to, comply with a law that has a penalty provision? No, this transparency bucket is very different than the Sunshine Law bucket. Now, in answer to this question that we received, can we have how much VRDD spent on transportation? Can we respond with a record? Yes. In fact, that's always preferable. We should never, do more work than we need to. We shouldn't reinvent the wheel. We shouldn't undermine DESE's position by providing information that is, possibly different or something that wouldn't match up with what we've published in different areas on a website or provided to the legislature. That's always the preferable position. So if, we got that question, the answer probably would be, here's our budget book. So often the answer to an information request is in fact a record. Sometimes it isn't though. So, sometimes we get these information requests and we have to decide, are we going to create a new record to respond to it? Now the Sunshine Law, again, we'll go back to, the Sunshine Law says we never have to create a new record to respond to a request. Information requests, now we're in the second bucket, are similar. We do not have to create a new record to respond to them. Whether we choose to do so or not is a collective decision. If you receive an information request, which you often will, whether or not you're going to respond to it depends on your access to the information that's being requested, how much time it will take, how helpful to DESE it would be for you to create this new record, it's also something that probably requires a discussion between you and your supervisor and possibly a lot of other folks in the agency, perhaps communications, perhaps the assistant commissioner in your office, maybe even the commissioner, maybe Mike Harris and our legislative director. It's sometimes a complex question that needs to be answered. So the answer to whether or not we're going to create a new record for an information request is not a yes or no always answer. It depends on the facts and circumstances. And it's one that should always be looked at thoughtfully and carefully. Okay, so after taking that little side road to talk about information requests versus Sunshine Law requests, let's swerve back onto the main road and talk about Sunshine Law requests a little bit more. So, remember, we said that Sunshine Law requests of records make governmental body records available upon request unless there's something that makes them closed. So records are presumed open. However, if there's a federal or state law that makes them closed, that does give the agency, that gives DESE the permission to close them. Something very important to keep in mind, though, is there has to be a state or federal legal exception that allows DESE to close records, or any other governmental agency. It has to be more than a gut feeling that, oh, it seems like these records should be closed. Okay, so let's talk for a second about how this works. Sometimes we have a feeling that records should be closed, or we have a belief, and that belief really isn't always accurate. And the other thing to keep in mind is just because records are closed in some circumstances doesn't mean that that always holds true. It depends on the facts. So let's explore that a little bit. So the first square that I've already marked for you is personnel information. So whether or not personnel information is closed depends. Personnel information is normally closed at the agency's discretion. So DESE normally closes personnel information such as discipline, promotion, performance ratings, HR type records. That's not always true, though. That can be waived. Agencies can provide personnel information. They can waive that closure under certain circumstances. And one circumstance that might happen could be if an employee has acted very badly, has acted in a way that the state agency might want to inoculate itself from those bad actions and say to the public or whomever that, hey, this employee was acting on his or her own and wasn't acting under the directives of the agency. And so we're going to release a certain small amount of records to demonstrate that. Okay, so again, personnel information, the ability to close that information is an exception under the Sunshine Law. Another exception under the Sunshine Law is the name of employee along with salary, location, and start and end date. So normally personnel information is kept closed except for those, circumstances that we talked about. However, the name of employee along with this other information, we always have to provide. So it's an exception to the exception. If we got a Sunshine Law request tomorrow for all DESE employees for their names and salary, location, and start and end date, we wouldn't have the end date for current employees, but we would have to provide it because it's an exception to the personnel exception. Hopefully many of you know that this information is already available to the public on the Missouri Accountability Portal. Again, this information is always available pursuant to the Sunshine Law. So let's talk about another example. Now, we know that student information is normally considered closed, right? However, we're going to put this in the depends category. Now, why is that? Well, there are lots of exceptions under FERPA. And FERPA is the Family Educational Rights and Privacy Act, for those of you who aren't familiar. It's the federal law that protects student records. However, just like the Sunshine Law, there are lots of exceptions. In fact, there are even more exceptions under the Sunshine Law or under FERPA than there are the Sunshine Law. And, we could name lots of them, lots of those exceptions. It could be that there's a release to allow the student information to be provided. It could be that the information is aggregated. It could be that the information is sent from one school to another school. Those are all allowable under FERPA. So that's why that goes under the depends category. A final one we'll look at here is attorney work product. We never provide that, and there's actually not an exception to that unless an attorney has reviewed it and said, it doesn't fit under this category. So if you receive an email from the attorney in your office that has attorney work product, or it could be abbreviated as AWP, don't forward that on. That's an email with legal advice between you and that attorney. And if you forward it, you have breached that confidentiality. So if you do that, then we can no longer close that record if it's requested. Just kind of wrapping up this idea of exceptions to the presumption of openness. There are a number of exceptions in the Sunshine Law that allow records to be closed. There are lots of them listed in this presentation that you can go back and look at. We don't need to go into them in depth. These are all exceptions, again, that are found in the Sunshine Law. And then there are exceptions that are found outside of the Sunshine Law. And I've just listed the ones that we deal with most commonly. And then I've listed a federal exception, again, that we've already talked about a little bit, FERPA, that certainly we all have some familiarity with. Final thoughts on provisions for closure. You need to have some familiarity with the provisions for closure that are specific to the work your office does. That doesn't mean you have to know them chapter and verse. That doesn't mean you need to have a long list of them that you're consulting on a daily basis. That just means you need to be thoughtful about the records that you have in your office and what types of laws might apply to close them if they were ever requested. Because if we do get a Sunshine Law request that applies to the records in your office, that might be a question I might have or some other legal counsel might have about whether or not those records are closed, or what types of confidential information the records contain. Okay, again, just because something seems personal or private doesn't mean it's closed. This is a hard concept for a lot of people. Sometimes it seems, a little bit icky or difficult to see records that have what appear to be confidential information be provided upon request. But unless there's a specific law that closes them, we have to provide them. We also need to be suspicious of a request that would appear to reveal identifiable information about the people that we serve. That doesn't necessarily mean that the request would be denied or that we can't provide the information. It just means we need to give it a second look and see if we can provide everything that's being requested, if some of it would be closed, how would we respond to the request. And that's something that the legal counsel that's responding to it or I would be having a conversation with the program staff in your office about. Always ask for guidance if you want clarification on the exceptions that apply to records, or if you have a chance to review the records that are being provided upon request, if you have a question about how something was redacted. Wrapping up that slide that we looked at the beginning, the Sunshine Law makes records of a public governmental body available upon request unless there's something that makes them closed. How do we respond to a request? So I've already alluded to this a little bit, but when a public governmental body receives a request, it has 3 business days, not counting the date of receipt, to send a response. So what do we mean by sending a response within 3 days? Well, it doesn't necessarily mean that we have to send the records. It means that we need to send one of the following. It means either a statement that we don't have the responsive records. It means we do send the requested records because we've been able to locate them within 3 business days. It means a time and cost estimate, if that's applicable for the requested records, or a time estimate for the time and cost estimate for the requested records. Okay, so let's go back for a second to talk about those 2 buckets, the Sunshine Law request bucket and the information request bucket. So we sometimes get requests for records that are really requests for information. It will start out by saying, under this Sunshine Law request, I request, a report showing every student in Boone County with the, last names M through Z that receive free and reduced lunch. I don't even know if we can produce that, if we'd have the information to produce that. We certainly couldn't produce it under FERPA, but let's just say we got that request. So, let's just take that as a hypothetical for what it's worth. Okay, in that case, it came as a Sunshine Law request. So it's in that bucket right now. As we look at that request, we know already we don't have a record that is responsive. So when we think about the checklist of what makes a Sunshine Law request, we do not maintain a record that is responsive, and there is not a record in existence at the time of the request that is responsive. So it shifts over to the information request bucket, right? So now we're in information request bucket, and we go through sort of the factors as to how we are going to respond. Do we have the information to respond to this request? Well, I'm not sure. Is it something that we could even respond to if we wanted? Well, it's asking for FERPA protected data. How long would it take to respond? I don't know. Those are the kinds of things that we'd have to think about. That's really what we would call a data request. And that's often what happens is we'll get something that looks like a Sunshine Law request. We don't have a responsive record. It's really asking us to create a data report. And it's probably going to make a lot more sense than the hypothetical that I just gave you. Now, whether or not we're going to respond to that data request depends on all those factors that we've already talked about. Do we have the data? Is it easily accessible? How beneficial to DESE would it be for us to create this new record? What kind of conversations do we need to have within the department before we create the new record? Because once we create the new record, right, then we do have a record that is maintained by the public governmental body and in existence at the time of the request. So once it's created, we do have that record. When in doubt, treat a questionable request, one that has both Sunshine Law request and information request elements, as a Sunshine Law request. Because as we've already discussed, the Sunshine Law request has timing elements. We have to send a response within 3 business days. Keep in mind, though, that Sunshine Law request requirements only apply to the records portion of your request. However, having said that, as a practical matter, it's sometimes easiest just to assume 3 days applies to everything. Even if it's an information request, even if you know you don't have a record that's responsive, just treat it for timing purposes like a Sunshine Law request. And that way, there's no misunderstanding. If you do happen to have a record that's responsive somewhere, we haven't misidentified the request, and we haven't blown a deadline. Let's run through a couple of hypotheticals that look at information versus records requests. So the first hypothetical is, can you please give me the job title, start date, and salary information for Sarah Madden in DESE? Now, is this an information request or a records request? So how we analyze this? Are they asking for a record? Well, the answer is no. However, there's a specific provision of the Sunshine Law, if you remember that sort of tic-tac-toe board we looked at, that makes this information available upon request. We should treat it like a Sunshine Law request and provide an answer within 3 days with the specific information that's being requested. Okay, so let's do a little bit more complicated one. Has the Brookside Charter School application been renewed by the Board of Education? What are the relevant state regulations for charter schools? May I have the APR information and district report card information for the Kansas City School District? This is actually a very typical looking request. We've got some things that look like records requests, some things that look like information requests. How would we time this? Again, my advice would be we just assume everything has a 3-day time limit. Again, that doesn't mean we have to provide a response to everything within 3 days. That means we have to send a response within 3 days. And that response can be, we've gotten your request. and we'll provide responsive records and a full response within X number of business days. Okay, so let's break this down. Has the Brookside Charter School application been reviewed by the Board of Education? So this is a request for information, right? They're not asking for records. Could we provide a record in response? Yes, absolutely. We could provide a record that has a date stamp on it or something like that, or even better, we could provide the board action that's on our website. What are the relevant state regulations for charter schools? So this is a request for records. However, this is a little bit of a trick because these aren't records that we maintain, that DESE maintains. These are records that are maintained by the Secretary of State's office. Now, having said that, is it an appropriate response for us to say, these aren't our records, please go talk to the Secretary of State's office about it, good luck? Well, no, that's not really the best response. That's not good customer service. It's not hard for us to provide a link to the Secretary of State's page with the appropriate regulations. May I have the APR information and district report card information for the Kansas City School District? So this is also a request for records. And here, this information is available on our website. We could provide a link to that. That's a perfectly appropriate response. Okay, so let's talk for a second about workflow. There are two ways in which a Sunshine Law request might arrive at DESE. One is through the custodian of records, and our custodian of records is Mallory McGowan, who is our communications director. Those communications director or custodian of records communications could also come to me. They could come to Billy Keim, who's the administrative assistant for the chief counsel's office. So that might be the direction that those requests come. And let's talk about that workflow for a second. If we receive a request on the 6th floor or the chief counsel's office in the Jefferson building, what will happen is we will look at it and try to determine who should respond. If we know immediately by looking at it, we will send it to that office or that person. If by looking at it we can't tell if it's a request for records for an individual, for example, and it doesn't specify, that this person attended state schools or is a VR client, for example, we simply don't know where that request needs to go. So, it could be that individual did attend a state school or was a adult education learner or, received an award from one of the, services that OCCR provides or was a VRDD client. It could be any of those things, or it could be overlapping things. So what happens is we send it out to the whole executive leadership team. The executive leadership team, or ELT, will then send it out to the appropriate staff. So that's how it might arrive at your desk. When you see a request like that, what you need to do is look at it and decide, do I have any responsive records? If so, how long will it take me to search for those records? And by searching for records, what we're looking for is searching for paper records and searching for electronic records that are stored on your computer. Could be anywhere on your computer, whether it's on your hard drive or files or SharePoint, any of those formats. If it's specified, you may need to look in other places. Now, you do not need to specifically look for emails. If you have an email that is 100% responsive, please let us know. But otherwise, we will conduct an email search on our end. So when we're asking for time it takes to search, what we're looking for here is the time it would take you to search in hours or minutes, and then the number of days it would take. So if you think it's going to take you 4 hours to conduct a search, that might mean 2 days, because you can't set aside 4 hours in one day to do a search. Or it could be it's going to take you 10 hours and 2 weeks. That's the kind of breakdown that we're looking for. And then you'll send that to your supervisor, or maybe you need to have a conversation with your supervisor about it. Your supervisor will send it to your assistant commissioner, and that will be sent to me. If you have any questions on how to calculate your time, feel free to give me a call or Billy Keim a call. You know, the other way that this might happen is you're sent a Sunshine Law request. And again, just like information requests, I think this is happening all the time. That's fine. If you are able to handle a Sunshine Law request, if you're able to identify a Sunshine Law request and respond to it within 3 business days and you know, complete that task, then you know, we don't have any concerns about that. But here are a couple of ground rules. You know, one is it does have to be responded to within 3 business days. The second is it can't cross any other offices, meaning you have to have the documentation within your office to respond to it. The third is, you know, the material or materiality, I guess, of the request. You know, the request can't really relate to any issues that the legislature is concerned about, that have been the subject of media inquiry. It has to be a pretty benign issue. If you have any questions on that, always give me a call. And if you know you want any help on those kinds of requests, always just send them to the 6th floor. Always send them to me or to Billy Joe, and we'd be happy to help you get them resolved and get them completed. Okay, so you know, last thing on you know, the workflow is you know, this slide explains how we charge for Sunshine Law requests, and the fees and the fee schedule comes directly from statute. Okay, so we're going to just wrap up the slideshow with another really important concept that overlaps with the Sunshine Law, and that is records retention. So first we're going to talk about retention of records just generally. And you know, I hope all of you are familiar with the Secretary of State's records retention schedule. That schedule outlines how long records have to be retained, and the basis for the Secretary of State's retention schedule requirements really relates to the value of the records. And that value comes down to, you know, does it have a fiscal value? Does it have an administrative value? Does it have a decision-making value? All of those things need to be looked at, you know, when examining the record to determine, you know, whether a record needs to be kept. But really, it comes back to the retention schedule, you know, to decide what category of record, you know, it falls into, to decide how long and where a record will be ultimately kept, or if it doesn't need to be kept at all. So, you know, this first small circle represents all the documents that have to be retained under the retention schedule because they have that administrative, fiscal, or decision-making value. And then this bigger circle represents everything else. And the documents that don't have to be kept are called transitory documents, meaning they only have to be kept for the time that they're needed. And those types of documents include draft memos, messages to yourself, things that are replaced by the permanent document. Let's do a quick hypothetical about what we're talking about here. Let's say you wrote a note to yourself that says, you know, must do Sunshine Law training, it's required, don't know why, and you put that in your desk. And then after you finished this training, you pulled the note back out and you said, not sure I got my money's worth. You know, we'll have to follow up with Sarah Madden because so many questions left unanswered. And then let's say in, you know, a couple days, we got a Sunshine Law request for all documents related to Sarah Madden's Sunshine Law training. So the first question is that a document that would likely have needed to be retained under the Secretary of State's retention schedules because it has administrative, fiscal, decision-making document. It's something that has permanence to it. Well, the answer is no. It's a transitory document, right? But the minute we got that Sunshine Law request, let's go back to that slide where we talked about what a record request has to have. It is a document in existence at the time of the request, and it is maintained by the public governmental body, right? So it automatically shifts over to the smaller circle. It is a document that is retained. Whether we needed to retain it or not, it is retained now that we've gotten the Sunshine Law request. And so it would have to be produced, really regardless of, how important it is or, the value of the document. So what this should be making you think about is, the fact that we have lots of documents that we keep that have no value, that we're not required to keep under the retention schedules, that, really we don't think about at all until maybe we get a Sunshine Law request. And the same thing happens if we get a legal request, like a subpoena. As soon as we get that request, we have to produce the document. And that sometimes causes problems. So, bottom line here, we need to keep the records that we are required to keep under the retention schedule. We need to, and I'm just going to move through these slides to get to the key concepts here. We need to keep the records that we're required to keep. However, we shouldn't be keeping the records that we're not required to keep. Now, there's a big loophole in all of this, and that is emails are permanently kept by the state system. They cannot be deleted, regardless of their value. So you could send an email that says, my cat is sick and I can't come into work today, which is extremely transitory in nature. It has no decision-making or administrative or fiscal value, right? It's not something that would need to be kept under the retention schedule, but it cannot be deleted. So it's kept forever. It's something that if you wrote it on a piece of paper and gave it to your boss, it could be destroyed. But because it's in the email system, it can't be. Again, this should be making you think, what are we putting in emails? Please be thoughtful about that and our permanent retention requirement for emails. Trust me when I say that after looking at thousands of emails over the years, hundreds of thousands of emails over the years, I've seen a lot of things that people probably wish they could have deleted. But that's not an option. And I've seen a lot of things that I wish we didn't have to provide to people upon request. So that's always something to be aware of and to be thoughtful of. So again, cannot emphasize this enough. If we need to be keeping something under the retention schedule, we should be keeping it. And if we have any questions about how that works, please give me a call. Please talk to your supervisor. Your administrative assistant often has a lot of knowledge about how those retention schedules work. But if we don't need to retain something, put yourself on a retention diet and look about your office and on your computer and think about what you can be getting rid of that would be in compliance with the law. Okay, so final thoughts here. We need to remind ourselves about the fact that our emails and our text messages that are work-related, calendar entries, internet histories are subject to the Sunshine Law in most cases. Again, unless there's something that makes them closed. We shouldn't put something in an email or a text that we'd be embarrassed to see on the front page of a paper, because that's always a possibility. In the review of records pursuant to a Sunshine Law request, if we find violations of administrative policy, we're going to refer that to Human Resources and your supervisor or your assistant commissioner, and we have done that. And I don't want to end this on a down note. I do want to thank you so much for your time. If you have any questions about the Sunshine Law or about anything in this presentation, I always welcome those questions. Feel free to give me a call or send me an email. Thank you again for your time.